All right. Hello, everyone. Welcome to our April coffee chat. I'm sure we'll have maybe a couple more people floating in here as we're getting started or throughout. My name is Erin. I am the marketing coordinator here at Stein Financial Group. I know I'm probably a new face for most of you, but we're excited to be back hosting these coffee chats again this year. This is our first one of the year, so we're excited. Um, just as a refresher, or if this is your first coffee chat, we do partner with Twin Engine Coffee for these chats. So if you attend all of our coffee chats throughout the year, you will receive a free bag of Twin Engine coffee on us. So you guys are all off to a great start with that. So you'll definitely want to make sure to keep your eyes out for all of our upcoming coffee chats throughout the year. We also have, kind of going off of our partnership, we have a Stein discount code for Twin Engine, and you can find that on our client dashboard page. We also have some more information about Twin Engine Coffee and more about our coffee chats too, so you can go check that out through our website. So definitely want to be sure to check that out. And today we have Brad Frank here with us from Barnes Thornburg, just to chat and answer any questions that you guys have. As a reminder, we want these to be open Q&A conversations. So if at any time you have questions, that you can feel free to hop in, or definitely throw those in the chat box, because that's what we're here for. Questions for us or for Brad specifically. So yeah, just as a reminder there.
I'll add to Erin's reminder that the coffee chats are open video. So I see we've got Ann and Randy have got their videos on. So everyone's welcome to turn their video on and just participate in the conversation over the video, over the Zoom call chat. Or like Erin mentioned, if you feel more comfortable just typing it into the chat section, you can do that too.
Yeah, for sure. All right, so we'll wait to see if we have any questions from the audience. Otherwise, does anyone here on the team have a question to get us started?
I'll kick us off. Bradley, it's great to see you. Thanks again for taking the time to join us today. I've worked with Bradley for a number of years, always a pleasure. And Brad, let's start with the basics. First of all, what's a will? Why do I need a will? And do I have to use you or somebody who does what you do to write that will? What are my options?
First, thanks for having me. I'm glad to be here, and I feel very much the same. I always enjoy working with Jeff and with the whole team at Stein Financial. What's a will? I'll start there. You know, a will is a document where you get the chance to say how you'd like your estate distributed when you pass away. And in addition, you get to name who's there to administer your estate, both in the role of what's now called personal representative. It used to be called executor. That's the person who does sort of the administrative part of the estate administration. And then trustee, if you decide to leave your assets in trust for any of your beneficiaries. But, you know, that being said, there's sort of a lot of other documents that can control the distribution of assets, particularly for like financial assets. Beneficiary designations are going to control over and above a will. And so a lot of people, you know, can and do rely on those to distribute the, you know, bulk of their estate, either through non-qualified accounts or through retirement accounts. And then some of those people end up choosing not to need a will because, you know, they're sort of taking care of what they need to. So, you know, the answer to do I need a will is sort of like a lawyerly answer, which is maybe. And it depends on what assets you have and how you want to distribute them. So, you know, relying on beneficiary designations can work well if you're leaving assets to people who kind of don't need additional protections or controls for them. So, you know, adults, maybe adult children, for example, who sort of don't need protection from creditors or protection from themselves or additional support managing their assets. Well, then, you know, for those kind of people, beneficiary designations can work just fine. Whereas, you know, if you have minor children or maybe a beneficiary who you're a little more worried about how they might administer assets, or, you know, protect them from their creditors or their future ex-spouses or other people, you know, a beneficiary designation isn't going to necessarily allow for that. And so in that case, you'd more likely want to go down the path of a will or revocable trust, which we'll talk a little bit about. Do you need a lawyer to do a will? No, there are, and I'm sure the answer as AI continues to develop might get more and more no for some people. You know, right now there are the LegalZooms of the world and other tools out there that, you know, can provide you with a will. You know, it asks you for certain inputs like names and ages and that kind of stuff. But you know, I found over time, as you know, once in a while I'll see like a client has done one of those and, you know, wants to redo it or wants, you know, to see if it works the way they think it does, that kind of stuff. And I think the issue really becomes, you know, it's one of those like you don't know what you don't know kind of situations. And once you have any level of complexity, whether that's, you know, you want to do things a little differently for one of the beneficiaries, or you may have, you know, assets that you want handled slightly differently. At least from what I've seen, the sort of automated programs out there aren't so good at dealing with those complexities, partially because, you know, without talking to a person, you might not even realize what some of your options are. And or you may not realize where some of the pitfalls might be. So anyway, you know, you certainly can use those automated systems for certain plans, but usually they have to, at least in my experience, it really only works if they're like quite straightforward.
Yeah. I was gonna say, I have a question then, Brad. So if I already have my will and I've done it, but I did it in a different state before I moved to the state of Minnesota, do I need to have it updated or like reviewed by an attorney here in Minnesota to make sure it all transitions or would work the same? Especially because I do have young children. Like, so how does that work?
So if you execute a will in another state, it is technically valid in each other state in the U.S. But we usually find that it's worth having it reviewed to make sure it works. First of all, to make sure you remember how it works and it works the way you think you remember it works. But also to ensure that there's nothing sort of funky in the state you came from, you know, because the state, even though the wills are valid in each other state, laws obviously do differ. And sometimes wills are drafted, you know, always wills are drafted in the given jurisdiction to comply with that jurisdiction's laws. And so you want to make sure that there's nothing sort of that's missing or that will end up playing out differently than you thought. And then also sort of more on the logistics side, you know, we find that, again, even though like, I don't know, Florida will is valid in Minnesota, it tends to be easier for administrative purposes if you do have a document of the state in which you live. The other thing I would note, sort of a flip side of that slightly, is for snowbird types. You know, so let's say you were a Minnesota resident, you become a Florida resident, not an unusual story, especially when it snows on the like second weekend in April. You know, your Minnesota will is valid in Florida, but one of the items that Minnesota has on its residency audit list is whether you've updated your estate plan for your claimed new jurisdiction of residency. And so even for our clients who are, you know, originally Minnesota based, who moved to Florida, you know, our recommendation, or any other state, our recommendation is do an estate plan of that new state so that the state of Minnesota can't use it against you that you haven't done that as you go forward.
Okay, good to know.
Yeah, and Brad, going back to one of the things you said first which I reiterate it because it's such a common question when someone comes in to talk about, do I need a will? And in general, we recommend that everybody considers having one. But I think it is important to know what you pointed out at the very beginning, and I'll just reiterate it, is if you have on your, let's just talk about your investment accounts, with the stuff we wouldn't be managing for you. If you have beneficiaries on those accounts, that supersedes the will. That is controlling who gets it. Now, what Brad brought up was a great point. Once you put somebody as your beneficiary, it's just the money goes to them. There's no control over how or how fast or, you know, any of those other nuances that you might want to take into account. But that is, I think, is something that a lot of people don't realize, is we can set up all your accounts to have a named beneficiary. That basically means you can skip the entire probate process if all your assets are in that situation. On that note, then, Brad, kind of a follow-up question, another sort of corollary we get, and it goes with Kim's question, even if I haven't moved states, how often should I update my will? I mean, is that something that, should I wait for a major life event?
Yeah.
My kids reaching 18, or is it every 5 years? What would be your recommendation?
Yeah, so I'll tell you what sort of we do from a practice standpoint is we usually ping our clients every 3 years via just a letter saying, hey, you know, your file came up for review, anything you want to take a look at. Not, you know, to be blunt about it, not because we're looking to, you know, like churn files or anything like that, but because, you know, we find 3 to 5 years is probably about right to just take a look back at, you know, how have my assets changed in the time. You will likely hear from, you know, either your advisor or your lawyer if the law meaningfully changes. Certainly we would reach out to our clients. But, you know, have my assets changed? Has the law changed? And then, you know, just reminding yourself who you have named in what roles. As people, you know, relationships change, people age out of roles, people move away, different people come into your life, you know, and I think that's worth revisiting. So usually I say to clients, you know, we're going to ping you on a 3-year basis, but to your point, I usually suggest people kind of think of it in like 5-year increments. But that being said, you know, as you also know, like if there are large life events like children reaching certain ages, a big one sometimes is children getting married, or when you meet who you think is going to be their spouse. Sometimes that's when our clients ask us to remind them what it says about what happens when their kids inherit assets, because they want to make sure they, well, sometimes I can tell when they didn't love the first introduction to the new son or daughter-in-law. Yeah, you know, I think that's sort of the time horizon we're looking at. Usually, I mean, oftentimes younger couples will look at it more often, especially as it relates to the guardian provision. That's something people really focus on when the kids are under 18. But, you know, the intent is certainly not to be constantly like updating your estate plan. So we certainly have clients who do it.
I have a question, Brad.
Hello.
We have 2 adult children. One lives in Tennessee, soon to be moving to Pennsylvania, and the other one lives in town. You are our attorney, and we need to update our trust. Can you do a Zoom call with the 3 of us?
Yes.
Okay, good, because I hate the parking down at your building.
If there's anything anyone takes away from the this Zoom today, I hope people know that the parking in the Capella Tower is not great.
You have to have a very small car.
Yes, I know. It's as though they designed it for no cars that exist in today's world. But
right.
Whatever.
Or you drive down 17 floors.
Yeah, though now, yes. But though now, you know, downtown Minneapolis, you can park in the middle of the street and you're fine. So there's plenty of parking available. But yes, absolutely regular. You know, the one certainly unintended benefit of the pandemic has been, you know, it's much easier to sort of almost meet in person via Zoom. And that's actually carried over. And, you know, we'll talk about probate a little bit, I bet. But, you know, probate court involvement with the probate courts in Minnesota in general, but like in Hennepin County in particular, has become much more streamlined and faster as a result of the pandemic, because they have decided for uncontested hearings, things where people aren't arguing about stuff, rather than making people take, half day off work and come sit in a like sort of a cattle call type court proceeding, where if you're my client, you're unquestionably going to be the last one called, because I'm almost always last whenever I have to go to one of those things. But they're on Zoom now and permanently. And so that's actually a nice offshoot of all the new technology our society uses.
But if you have a trust, you don't have to go through probate.
Maybe.
Oh.
And that, Anne, is what we call a segue in the business. So, okay. So I'll go down that path. So, we've been talking about wills. A different way that a different document you can have that's your core distributive document of your estate plan. It's what we call a revocable trust. You'll hear it referred to as a living trust as well. And so, that would be the document where you say, if I'm gone, if the first spouse is gone, here's what happens. If we're both gone, here's what happens from a distributive standpoint. And here's who we name as trustee to do all these things that we're laying out. And then, to Anne's point, you can avoid probate through that, because if you take your assets so assets that go through probate are assets owned in your own name when you pass away with no beneficiary designation, and they're not owned jointly with somebody else. If during your lifetime you implement a revocable trust, and then you take those assets and retitle them from your own name to your revocable trust, when you pass away, for legal purposes, you don't own those assets, the trust does, and therefore they don't need to go through probate. But to Anne's point, just having the trust in and of itself doesn't save you from probate. You've got to take that second step. You need to retitle the assets that would go through probate from your name to your revocable trust. Otherwise, you've gone through all the time and cost of creating this trust to avoid probate, but then you didn't avoid probate because you have these assets that are still in your own name. So you got to follow through after executing the trust. So a revocable trust allows you to avoid probate, but you do have to take that extra step.
Bradley, take me a step further. We're talking about assets. We're talking about retitling. What does that mean?
So depends on the asset. So to take a sort of useful example here of a investment account. So, if I, Brad Frank, had an investment account at Stein Financial Group, that would just be in my name, right? But if I enter into a revocable trust, we would fill out the forms to take that asset, the investment account, and change the title from Brad Frank to likely Brad Frank as trustee of the Brad Frank Revocable Trust. Right. And so that is for that kind of asset. Certain assets have certificates of title, like cars and boats and those kind of things. Houses have legal title via deeds that are on record with the given county. And I think most of you are sort of generally aware of your types of assets and how you hold title. And then the question is just going about the process for each given asset and thinking about, well, is this an asset that will cause probate? If it is, can I retitle it? So, for example, one step, if you have a revocable trust, sometimes is to retitle your home or maybe your cabin from your own name or joint names into one spouse's revocable trust, the other spouse's revocable trust, or maybe together between the two revocable trusts. But if you have a mortgage on those properties, we as your lawyers are going to tell you, you're supposed to ask or talk to your lender prior to retitling, because many mortgage documents have what's called a due on sale clause that could be triggered if you retitle the property without the consent of the lender, even though you're really just effectively moving it from yourself to yourself. I think very technically they could squawk about it and call your mortgage, which certainly you wouldn't want to do generally, but especially because a lot of us probably have mortgages that are at much better rates than the ones available right now. you really don't want to give a mortgage lender leverage to monkey around with your rate or your mortgage. So, so when I say, you know, certain assets you may not be able to retitle or you may not want to retitle, it's worth going through that process. Sort of, if you think of your sort of essentially your informally your balance sheet, to kind of tick down each asset and say, okay, what's the story here? Do I want to retitle it? Also, one thing to note is, so let's say you have a revocable trust, you retitle a bunch of stuff into it, but you have some sort of like lagging assets, I guess I'll say. Like, a lot of people don't retitle their cars. Most of our clients don't retitle their, what I'll call operating bank accounts, you know, their checking and savings accounts. You can still avoid probate on some of those assets. Certainly, like checking and savings, you can name a beneficiary through a transfer on death or a payable on death designation with your bank. But also in Minnesota, we have a sort of small estate threshold of $75,000. So if you have aggregate assets that would otherwise cause a probate that are together are worth less than 75 grand, you can still avoid probate on those assets. And you can use an affidavit to go to the, you know, financial institution or the DMV or wherever and retitle those assets without a probate. So oftentimes, even if somebody goes through this whole process, they'll still have, you know, sort of a bucket of lagging assets that they don't bother to retitle.
And then as long as those are $75,000 or less in total in aggregate, then you can just go do the special affidavit and have them. Moved. Very cool.
Brad, so what would be the trigger between, you know, I don't really need anything because I can pretty much take care of the 75,000 plus assets at Stein Financial that will go under the beneficiary designation versus a will, which you said, like in Hennepin County, it's not as big a deal as it was, versus a trust versus something else.
So, you know, oftentimes people focus on the value of their assets, which certainly does kind of dovetail with a lot of this. But to me, it's really more two things. It's types of assets, and but most meaningfully, it's how you want to leave them to whomever you're leaving them to. So if you know, relying just on beneficiary designations and an affidavit of collection works really well if you're okay just handing assets over to people. And, you know, if your beneficiaries are people you're comfortable just leaving things outright to them and letting them go on their way with their inheritance. To the extent you want to exercise any level of additional control on any assets you leave to anyone, meaning you want to make sure those assets are either maybe held till they reach a certain age or distributed to, you know, a trustee for their benefit because you're worried that they have creditors or can't manage their own finances. I think when you have that kind of situation, it's certainly a question of when I want to go up at least to a will, because through a will, you can exercise those kind of things. Also, if you have a taxable estate, which in Minnesota is that we each have a $3 million exemption from Minnesota estate taxes. And then federally right now, we each have a $12.92 million exemption from estate tax, which is sort of, you know, exceedingly high and historically high, and actually is going to likely keep going up a bit over each of the next 2 years. If you're in either of those situations, you certainly likely will want to go to using a will or a revocable trust, because you'll want to sort of efficiently and effectively take advantage of those exemptions. And you can't always do that via beneficiary designation. And then the question between a will and a trust, you know, when do I go from a will to a revocable trust? That again gets back to how much you want to avoid probate. And the reasons people really tend to want to avoid probate are there is sort of some cost and time associated with it, even though it's become more streamlined. Even sort of like the simplest probate, if you use a lawyer, which you don't have to do, but most people choose to use a lawyer in their probate, it's going to cost the estate between filing fees and attorney's fees, probably at least a couple $1,000, if not more. And then the other reason people don't like probate is it's public, which isn't to say that in most cases, there's not like a open court hearing anybody could go sit and watch. That happens when there's something sort of wrong, where people are fighting or there's a lost will or things like that. But it's public in that the information is public. And so a lot of people don't love the idea about their sibling or their neighbor or whomever being able to go in the court records and see generally what types of assets you had when you passed away and how much they're worth. So the sort of distaste for that and the cost and time are what drive most of our clients to move between the will and trust. The last thing I'll say about when you move between a will and trust, we've been talking about probate here in Minnesota, probate in Hennepin County in particular, not as big a deal anymore. Probate in the jurisdictions where Minnesotans tend to have second properties still is not great. And those are like Wisconsin in particular is an extremely expensive probate state, the way they calculate their filing fees. And then Florida, Arizona, California, Texas, the places Minnesotans tend to have second residences, it's great that they're non-tax jurisdictions, but they got to make up for it other ways. And sometimes that's via filing fees and other sort of annoyances, and many of which come with costs and time. And so for our clients who have, all their stuff in Minnesota, but then have the condo in Florida or the, cabin in Wisconsin or whatever, a lot of times those clients also choose to move from like a will structure to a revocable trust structure, not because they're so worried about Minnesota, but to avoid probate in those other places.
Is there any advantage or disadvantage we have a lake home? Would you advise like putting it in our son's name now, since he's going to get it anyways, because the other one doesn't live in town?
That's a gift, so that doesn't mean it's bad. But so one disadvantage, right? So if you want to give it to him, you certainly can. You just you're allowed to give him $17,000 a year right now, but of value. And then on top of that, if you wanted to make a bigger gift, which this would be, you can use some of that $12.92 million exemption from federal gift and estate tax that I was talking about. And so you could do that. You could make the gift and report it, and that's great. It's out of your estate. And that would obviously avoid probate. But the downsides are, I'm going to go ahead and guess your son doesn't want to pay for it yet for the because everyone loves a cabin until they have to pay for it. Right. And so you'd have to figure out a structure. Well, it depends what your deal is with them. If you have if your deal is, yeah, he can have it, but he's got to pay for it now, well, fine. But if the deal is he can have it, but now we're going to pay for it, then technically, usually you're supposed to enter into a lease where you guys would lease it back from him, and there are income taxes associated with that. So that's one.
So maybe it's just better to wait till we die and then he gets
maybe.
it.
And then the other thing I was going to note is currently sort of the trade-off for the existence of the estate, or a trade-off for the existence of the estate tax system, is that on the income tax side of the world, any non-retirement assets that you own when you die receive a step up in basis for income tax purposes. So if you guys paid $10,000 for the cabin and now it's worth $100,000, if you sold it, there'd be a $90,000 capital gain. If you die owning it, that capital gain gets wiped out, and your son would take it $100,000. He could turn around and sell it without capital gains. Now, cabins, often the plan isn't to sell it, but you certainly want to think about the income tax consequences of giving away assets because of the way our systems kind of work together.
I think we'll wait till we die.
That's a key piece, Bradley.
Yeah.
I was going to ask if Randy, did you guys have a question? I saw like a hand raised or a thumbs up, so I wasn't sure if you guys had a question.
Well, I have one of my questions is if you do have a revocable trust set up, can that revocable trust be a beneficiary in those assets that you would normally name a person?
Yes, but I wouldn't recommend that with regard to retirement assets,
Right.
because, long story short, they in the last few years they've changed the way retirement assets are taxed on the income tax side, and essentially, if you run them through a trust, it's very likely that they may end up having to be drawn down over 5 years rather than over 10 years. And so usually the recommendation, unless there are sort of unique circumstances, nowadays the usual recommendation is to leave retirement assets to a person. But otherwise, yeah, I mean, you can do that for like life insurance and other assets, sure.
And
okay. And I also have a comment. I am in the throes of handling the estate of my mom who passed in December in Wisconsin. Well, thanks. She and my father had set up most of their wealth in a beneficiary situation, and my mother had an insurance policy, that life insurance policy she took out when she was 17 years old.
Wow.
But so those things, that was a piece of cake.
Right.
The rest of her estate in Wisconsin for transfer by affidavit is $50,000 of estate. And two things that I think might have been a benefit of having that probated is, one is the people at the Milwaukee County Courthouse would have talked to me. I'm an attorney, but I worked in corrections my entire life, so this is and they would not.
Yeah, they don't give legal advice.
Word one on what I should do next, and I looked at the statute, and the statute wasn't clear enough, oddly enough, so I could make a decision. And the second thing is fortunately, the Wisconsin attorney who helped my mother draft her will was very helpful for me. But one of the things he said is, when you do, and I don't know if that's the case in Minnesota, but when you do transfer by affidavit, you don't have the opportunity to post a notice to creditors.
That's true.
That has a expiration date. So theoretically, my mother could have a debt out there that 10 years from now would, of course, they'd have to be put to their proof, but there's nothing that's going to retire that debt.
That's right. The other, as a good Minnesotan who doesn't like to, rag on Wisconsin, but the other problem with Wisconsin, thank you. The other problem with Wisconsin is, just to give an example, and I feel like some people on this call may have heard this story before, but the way they calculate their filing fees, if you have to go through an actual probate, is based on the value of the assets in Wisconsin. And I had a former partner who passed away, who they owned a very, very nice cabin in northern Wisconsin. And he knew very well how to retitle his own assets. He knew he was supposed to retitle the cabin, and he never did. And it was worth $2.1 million at the time he died, and had to go through probate because, for whatever reason, it was just in his name rather than in their joint name. And so my paralegal comes in and says, here's the stuff for the probate in the county in Wisconsin, and we need a filing fee check for $21,000.
Oh my gosh.
And I was like, that can't be. I was like, I believed her, but I'm like, that just can't be right. And so, she and I looked at the form together, and, it was pretty clear she was right, but at the same time, I was like, we both have to be missing something because this is ridiculous. So we sent in I was like, we must be off by a decimal somehow. And so we sent in the probate application with a check for $2,100. And I got a call a couple of weeks later from the nice clerk in the county and said, everything looked good. We just need another $19,000. And so, so that's another meaningful downside to probate in Wisconsin. It's just the way they calculate their filing fee is sort of incredible to me. Wow.
And at that point, it's not a cabin, it's a lake home.
That's true. True. Fair enough. Fair enough.
Palace.
Or there, I think they might like to call them cottages. But yes. But yes.
it's okay to complain about Wisconsin's legal system, but don't badmouth the Packers.
Okay, well, that's a different seminar.
So
Thanks
Brad, I know we've talked a lot about like, okay, we might not need a will, but I think like in my mind, when I think about a will, there's other documents that like go with that.
Yep.
And so like, and I guess I'm curious if there's ever a reason to not have those other pieces or those other documents that I guess I associate with a will.
Yeah, and I think what you're probably talking about are a power of attorney and a healthcare directive.
Yeah.
To answer your question, I don't really have a good reason why you wouldn't want those. But I'll tell you why I get, and well, I'll talk about what they are quickly, but then I'll tell you about where I get pushback from clients on them from time to time. So what they are, sort of two other documents that generally are thought of as relating to, what happens if you're incapacitated. And one, the power of attorney is with regard to financial matters. The healthcare directive is with regard to your healthcare wishes. But I'll tell you sort of the what I sometimes see as the misunderstanding about each of those documents that people kind of come in with sometimes. So on the power of attorney, the financial power of attorney, the way the Minnesota statutory form works is it's what's called a durable power of attorney. And that means, somewhat counterintuitively, is what it says is, I'm naming this person as my attorney in fact to act on my behalf now, the day I sign it, and then it remains in place even if I become incapacitated, is durable. Now, I think most people would say, yeah, duh, that's how we want these things to work. But I think a lot of people think the way they work is what is legally called a springing power of attorney, which says, no, when I become incapacitated, this thing comes into effect. Now, which is not how the Minnesota form works. So the benefit of that is you don't get into cases on the financial side where you have to sort of prove up that somebody is legally incapacitated. So that's nice. So you don't have to go through that process in most cases to use a power of attorney. But the scary part, for lack of a better word, and the reason sometimes I get pushback is when, we have this conversation, clients are like, well, wait a second. I don't want my kids to have that kind of power right now, right? And you can, within the document, limit what they can do, when they can do it. The problem is, like, invariably, if you do that, then, 2 months later, you're going to need a person to do the thing you said they couldn't do under the power of attorney, right? Because like Murphy's Law or whatever. And so, so really, I mean, I think you should have a financial power of attorney in place, but people just, should give thought to who they name, certainly, because it's a very powerful document. And, obviously, like, people have a fiduciary duty once they're named in it, and they can't go about, stealing from you, essentially. But that's the concern I hear from people once in a while. On the healthcare directive, I think that one is like the lowest hanging fruit of all of these documents, and you certainly don't need a lawyer to do that. There are plenty of like readily available and perfectly good forms out there, whether online or from your doctor or medical system. But so one misunderstanding sometimes about healthcare directives is you're not naming someone who's supposed to take their own wishes for your healthcare and, put them in place of your wishes for your healthcare. The healthcare directive is intended to be a document where you get to say, look, as long as I can communicate them, I'm going to give my wishes to my doctors. When I can't, here's what they are, and here's who I'm appointing to read this thing and communicate with the doctors based upon it. That being said, like, don't name someone who holds very different views about healthcare in general or your healthcare in particular in the role of your healthcare agent. The other thing I would say is, even though it's the lowest hanging fruit, it's also the one that a lot of our clients maybe struggle the most with, sometimes because they don't want to think about the stuff, sometimes because they aren't sure what they think about the stuff, sometimes because they don't know who to name. And, I totally respect all of that, but this gets back to something we were talking about, half hour ago, which is, that's fine, I get that, but maybe it works best actually to do it for what feels right for now, and then go from there and revisit it from time to time. The other benefit of the healthcare directive in particular, so like the financial power of attorney is a statutory form put forth by the state of Minnesota. If you vary from that form, third parties oftentimes will not accept it or will give you a really hard time about it. And those third parties most often would be like a financial institution. But the healthcare directive form put out by the state of Minnesota is super flexible and is intended to be edited. Other than the HIPAA language, the privacy stuff, you can really change like anything in that document. And so it really can be, catered to your beliefs about your healthcare, your religious beliefs, your spiritual beliefs, anything. So it's a super flexible document. And I think, it really does make sense to have one in place. And one last thing I'll say about those two documents, again, coming back to like the snowbird example, oftentimes I think it makes good sense. So again, like a Minnesota power of attorney or a Minnesota healthcare directive is technically valid in whatever state. But again, for sort of ease of use, if you're spending a bunch of time in another state, it usually makes sense to, and you're worried about this stuff, it usually makes sense to have a healthcare directive and power of attorney for that state as well.
For the durable power of attorney, we have for both of our children to have it, and they get along great. I mean, they're each other's best friends. Is that a good idea or a bad idea?
For the second time to one of your questions, I'll say it depends. It does. It depends on who the people are in their relationships. I mean, I think
well, and one lives in town and one doesn't.
Yeah, I mean, that's a reason some people do that. I think sometimes people, some people say, look, I know they're going to like consult with each other about it, but I'm just going to name one of them for like ease of use.
Okay.
But I don't think, in today's world, just give it, with electronic communication and ease of electronic communication and DocuSign and all that kind of stuff, we see a lot of people do that and it works just fine. The one thing I was saying to a client yesterday, actually, we have found, so like, especially on the financial power of attorney side, I can tell you what all the legal ramifications are and requirements. I don't control what financial institutions require. And so we're seeing things like, if you have a power of attorney that's dated more than 3 years before you go to use it, oftentimes I want you to execute a new one.
Okay.
Even though it's perfectly legal. Also, we found once in a while we'll have somebody who wants to name or has named somebody who's not in the United States in a financial power of attorney role, and that can create a lot of additional work and annoyance as it relates to opening accounts to the know your customer stuff. And so my recommendation is usually if you have someone in the US, that's better.
Brad,
Yes,
Brad, I used to do, full disclosure, I've known Brad since he was about an hour and a half old.
Well, I was going to say, since you knew me in utero, I believe.
Yeah, it could be. And I used to do estate planning, but I've been retired for a while. But a couple of comments. One, you made a comment kind of in passing about, you can't control the financial institution. And that's for sure true. Right. And, because I used to do this, so friends tell me stories about this, that, or the other thing. And, if you have, for whatever reason, a bank account in a foreign country, and a foreign country can very well, it certainly includes Canada, and it can very well include New York. They want their power of attorney form. They don't want the Minnesota one. Eventually, you'll get them to take it, but it can be a really lot of work. So
it's hard enough to get a Minnesota financial institution to accept a Minnesota
exactly.
Yeah, exactly. Totally. Like this was pre-pandemic, but I once had to sit in downtown here, and there's a Wells Fargo branch in the IDS, and I was with a client with a power of attorney. We were there for like 2 hours. with a perfectly valid brand new power of attorney. And it was, yeah, anyway.
Because, well, sometimes, the banks, like many institutions, the people that they have out there are not as well trained as they were 5 years ago or 10 years ago. They aren't.
Yep.
So let's see, there was one other thing the other thing about the power of attorney is, if the client was absolutely sure it's going to be son number one or son number one and daughter number one or daughter number two or whatever, and that's who it's going to be, and I trust them with my life and nothing will ever go wrong, that's fine. If there was any question, what I told people to do is to tell their children or the person, it's in my drawer in my nightstand, and don't even tell them that it's them.
Right.
Because you might be somebody else, but you're my number one child. And so if something happens to me and you need to do a financial transaction, use the power of attorney. It's in my nightstand.
Yep.
And that way you can change it.
Totally. Yeah. People always ask us, when we execute the estate plan, should I give it to whomever? And, it depends on the situation, but usually the answer is no, just tell them where it is. And the one thing I would say about a power of attorney along those lines is don't put it in the safe deposit box, because then the document that says who can get in the safe deposit box is in the safe deposit box. Which we haven't had that one in a while, but it used to happen once in a while.
Hey, Brad, I got a question about like a healthcare power of attorney.
Yeah.
And can I set one up for my child to give somebody else permission to make a health decision for my child, like if I'm on vacation, country or something like that?
So what we've done in those cases is we've executed sort of like a temporary guardianship type document rather than because when it's a minor child, it doesn't exactly work to use a healthcare directive.
Okay.
But sort of different, and more and more we're getting the question about children who are just turning maybe 18 who then are going off to college. And more we're having clients have them execute powers of attorney and healthcare directives, both Minnesota and whatever state they're going to, before they go off to school, which I think is a good idea. Thankfully, I can't recall a situation where we've had to use one, but I think that makes good sense. And
Bradley, why would you want to do that?
Again, just once your kid is over 18, even though your relationship may be such that you have all the information you want and you control the strings and financially and otherwise, if God forbid something happens to them, they're in the hospital, they're over 18. And so, likely the medical institution can't talk to you about what's going on, even as their parent, because you're not their guardian anymore. And so that's the particular reason. Power of attorney matters, but that it's a little less of an issue if you're the parent and you have control over their bank accounts or whatever anyway. Which I'm sure will be the case with my youngest. He a few months ago, he's 9, he told me he needed a bank account. I said, why? He said, so you can put money in it. I said, you're not supposed to see through the situation that clearly. But,
I know I'm interrupting. I know Brad's youngest.
Yes.
Absolutely. That is a true story.
Well, I know we had a question from the chat, and while we get it pulled up here, I will echo what Art you said and what Brad you kind of echoed, which is as in our capacity, we've dealt with estate matters of getting powers of attorney to different financial institutions, and I won't name specific names, although I could, but
starts with WF.
Well,
it's one of them. Schmel Schmargo or Shmoo S. Bank.
Yeah, right? or Buntington maybe.
Yeah, fair enough.
But I have had a magnitude of 10 times more problems with banks than with investment companies or annuity companies.
I agree.
And I'm not saying any of those institutions are perfect. And I'm not saying everybody should just pull their money out of the bank, because obviously we all need banks. I use a bank, but it is worth trying to potentially simplify as much as is feasible and works for you prior to anything happening, because working with especially banks tends to be a a tough situation for your desired power of attorney.
Yeah, and a different way that comes up is, you know, we're talking about all these roles like trustees and executor and power of attorney as though there'll be people. You can name institutions in these roles, and it used to be a much more common practice to name, you know, at various times, like First Bank and Norwest, and we see Richfield Bank and Trust a lot, and you know, these entities that ultimately got rolled up into Wells Fargo and U.S. Bank in this market, and I usually strongly recommend to clients that they name a person if they can, rather than an institution, sort of for similar reasons, which is that these institutions, you know, sometimes they are useful if you have a very challenging beneficiary or certain other situations, because they're really good at saying no because they're extremely risk averse. But it feels like, especially the biggest ones in town, really don't want to be in the business anymore. But for whatever of serving as trustee, but for whatever reason, they do tend to continue to do it in certain relationships. But they are extremely challenging to deal with, and when you want out of them, they're not easy to get out of. You will get out of them, but it's painful on the way out. And so I would, you know, if that's a situation you have. And again, which was common for people doing estate planning, you know, even 20 years ago, I would, you know, suggest you might want to revisit that.
One of the things my parents did in their later years was put me on their checking account.
Yeah.
And so that it just made, plus we all went to the same bank, and so they knew it.
Yeah.
And so it made it just so much easier to pay their bills. But he looked at me and he said, "Don't you take anything."
Well, so to that last point, so yeah, what Ann's saying is, you know, rather than relying on a power of attorney, you can just put someone on as a co-signer on your account, right? And that kind of skips past the power of attorney issue. The thing you want to be careful about, and this gets back to Art's point, is that sometimes the person you're talking to at the bank, if they don't, you know, you don't know them very well, they don't know you, or they just don't understand what you're asking. Sometimes they don't. They do essentially what you're saying is, I want this person on as a signer. What they're hearing is, or what they think they're hearing is, I want this person on as an owner. And that's, you wouldn't maybe even notice it during, you know, mom's life, for example, but now mom's gone, and lo and behold, it passes to the sibling, the child who was helping mom with her bank account, because they're a co-owner, not just a co-signer. And in some cases, that's fine. But in others, you know, usually it's the child will say, well, that wasn't what mom wanted. Let's move this, let's split it, you know, in thirds, or however many kids there are. Well, that technically at that point is a gift, right? And so you know, that's an issue, but oftentimes that can be resolved. The bigger challenge is when that surviving child, or that child says, no, like, mom knew what she was doing, and I was supposed to get this account. You know, and thankfully we don't have that happen very much, but it happens. And that's not a fun conversation for anyone usually. Well, except for the one who gets to keep the money.
Right. So to get to that question, I apologize that it's gotten so long. The simple question, is there a range of cost for revocable trust? And presumably what would that cost roughly be for a very straightforward one? Yeah.
So again, going back to the baseline, like a legal Zoom, like if you try and do it yourself online, I can't claim I sit here and try those very often, but you know, my understanding is those run like $500 to $1,000, right? For anything sort of useful. With a lawyer, I mean, it's going to be quite a range, but I think you could, in this market, you can get sort of a quote unquote simple will done for probably around $1,000 with, you know, with perfectly, you know, functional lawyers. Revocable trust usually will cost you, and I mean, I recognize this is a large range, but between, you know, maybe a couple $1,000 to, I'm sure there's one firm across the street from me that'd be more than happy to charge you $5,000 to $7,500 for sort of essentially the same thing. And then, you know, there's all kinds of other estate planning that we're not going to talk about today, much more sort of advanced gifting that can get into the tens of thousands of dollars. But so the broad range, I think for a well done, you know, straightforward estate plan, including revocable trusts, I would say you should, in this market, you can certainly get that done for, $3,000 or less. But you can get a perfectly good estate plan with a will, with lawyers who I think would be worth going to, for $1,200 or $1,500.
One comment that I've got is what you're buying is, I always used to say it's my job to think of the questions that the client didn't think of.
That's right.
That are important to the client. And, you don't know to think about, well, what we're really doing is planning if both spouses die to take care of the children. And that's a little different mindset. And, to ask, well, I want of course we want the wife's mom to take care of the children.
Right.
Well, do you really? That can be perfectly fine, but she's a different generation.
Right.
And, is that something you may want to think through? So there are it was my job, and I suspect Brad doesn't disagree with this. It's the lawyer's job to think of the questions that are important that the client just doesn't think of.
Yes. I don't usually end webinars by quoting Donald Rumsfeld, but it's, the unknown unknowns, right?
Donald Rumsfeld. Whoa.
It's just in the paper the other
day. Yeah. And, that is a key point. And I would even make the corollary for everybody on this call from your estate planning, because that's an area with a huge amount of unknown unknowns, to even something like your taxes. Let's say we just got through, it's tax day today, technically. And for everybody on this call, if you haven't gotten our email, if you would like us to take a look at your taxes, we have the capability to analyze them for you. We're not CPAs, we don't do them. But if anybody on this call would like us to look through that and think about things that may have an impact on your estate, think about things that might have just an impact on next year, that's something we're doing. So we've sent out a few communications, but you reminded me of that, Brad and Art, and I wanted to make sure everybody knew that on this call, that if you haven't already, you can send us your completed tax forms and we will analyze them for you. Just like a good attorney would analyze your estate plan and ask you those questions that maybe you hadn't even thought of yet. So just a plug for us there.
We're coming up on our hour, so Brad, definitely thank you for your time. I don't know if anybody has any last minute questions, but as we end all of our coffee chats, Aaron's working on our little wheel, our spin wheel here, to see who gets a cup of coffee today on us for joining us this morning. But yeah, if anybody else has any other last minute questions, Brad, I don't know if you'd be comfortable offering that people could also just email or reach out.
Yeah, of course.
Questions too.
And we should say that off the top, Brad, it has been a great resource, but also partner for us. Brad is part of Barnes Thornburg. He's not part of Stein Financial Group, but we highly recommend Brad as a resource, and as Ann, you've used an actual professional in this space. And we have other people we recommend as well, but Brad, your name is at the top of the list. So anybody on this call who's thinking about doing this, we can get you Brad's info, and highly encourage. We love working with you, Brad. So thank you for being on today.
Thank you, and the feeling's mutual for sure.
I think, Randy, did you have one last question?
Okay.
Okay.
All right. Let's spin that wheel. Oh, congratulations.
Oh, thanks.
Randy and Sherry. Good job.
Yeah, drive downtown to get this coffee, or
We'll just send you a gift card and you can go get coffee wherever you want.
There you go.
Oh, that's great. My favorite coffee place is up in Switzerland. So
I mean, do they have a website? We can probably still get a gift card.
one.
Yeah, you cover the tariffs, and we'll see if we can work that out.
All right.
Okay.
We look forward to seeing you next week. Thank you, everybody, for taking part in this. Bradley, always a pleasure.
Yeah, no, thank you.
Any further questions? If we can be of service, you know, all you have to do is pick up the phone, send us an email. We're here to make the financial side of your life as easy as possible. And Brad, I've got dozens of more questions, so we're going to have to do this again. Thank you.
Sounds good. Thank you.
Thanks,
all.
Brad.
Thanks.
All right.
Thanks, guys. Take
Thanks,
care.
everybody.
Bye.
Great seeing you all.